Hey guys, it's Kathy. I hope you're doing well. Break time. Yeah, time for me to go on break, guys. Woohoo! Oh man. Okay, so we got a new excuse for our bingo cards today. And I haven't heard this one before, so it's definitely going on the bingo cards. And I found a way to get around the whole gambling license if we do bingo. You guys can just have a bingo card. It'll be electronic instead of a piece of paper. Um, and then maybe like we'll do it like once or twice a month, and only one person wins unless two people get bingo at the same time. Then two people win. But one bingo, whoever wins that one bingo wins a T-shirt with Court Vibes logo on it. But hi Monica, but only if you're willing to give an address that I can ship it to. And I know that's a stretch on the internet these days. That's a scary thing. All right. So, let's go with the new bingo excuse first. California.
So it sounds like he got arrested in another county. That county, due to overcrowding, released him, told him when he needed to come to court, and he didn't do so. So at this point, it doesn't sound like it's on the courts that haven't gotten Mr. Lowry to get himself here to finish his time. Sounds like it's on Mr. Lowry. So how much time does he owe? Because it doesn't, none of this indicates. It looks like 120 days. Is that my understanding?
Yes, Your Honor, 120 days with 4 days.
So the defendant has 4 actual plus 4 good time for a total of 8, right? Off of the 120-day sentence. So, sir, you still have approximately
2 plus 2 for 4.
2 plus 2. That's kind of good. The way it looks like it's 4 actually. We've been in since. Am I reading wrong?
Well, we usually go like based on the original sentence and the credits that were approved afterwards would be determined by the jail.
Okay. All right, so sir, you have 4 days total credit. No, at this point, that's sentence credits on the time, so you still owe 116 days on your sentence. The probation will remain terminated at this, or revoked, and will terminate upon completion of his time.
Everything that they have is just 60 days. To 60 actual. Everything. He pledged 120, correct?
Correct.
That's not correct. That's not correct. It was 90 with a misdemeanor. The 120 was with a felony.
I am talking about a felony.
This was a misdemeanor plea to 120
I
days,
didn't-
1 year of informal probation. Your probation is expired and the time is still owed.
That was still, that was 90 days. With the term.
Until 120 days.
All of the court records, including the court file, which is here present in front of us, where someone wrote it down the day that we were in court, indicates 120 days. So the court's going to go with 120-day sentence at this point in time. You have 4 days credit. You will be in custody until that time. Upon completion of that time, your probation will terminate in this case.
That's calculated, so whatever. Another almost 2 months.
It's crazy, like June flies. Sure.
Yeah.
It's not right. And probation expired. So,
Sir, let me explain something to you while you're standing here. There was a warrant that
Uh-oh.
issued within time while you were still on probation, revoking your probation. Therefore, your probation stopped at that point in time. I've left it continuing to stop. You owe the time that you pled to, and you were given multiple opportunities to come to court to deal with that matter. You didn't do so. So now you're going to have to do that time in custody. When you finish doing that time, then I will terminate your probation and you won't have any more probation hanging over your head in this case. You will not be released before then because you owe the time, sir. That is what you pled to in court. It's what you agreed to. May not be what you remember, but it's what the court file says, sir.
Okay.
And that's what we go by.
It's not what I pled to at all, but is there an opportunity to do this time as an alternative so I don't lose my house?
You can't, unfortunately, that opportunity is passed because your probation is expired. Sheriff's Work Project will not accept you at this point in time. Had you done it within the time period that you were supposed to have gotten it done, that would have been an option, but that option has passed you by.
There's no kind of volunteer work or anything?
There's no other option for you other than to serve.
Watch my house fall down?
To serve the time in custody.
Stuff I didn't plead to.
There's no other option. I'm going by what the court file says, sir. There was-
Wrong.
Well, I'm telling you,
I
sir,
did not.
sir, I've made my order. That's gonna be the order. There's nothing that's gonna change.
So there we go. I can't go to jail because my house will fall down. My house will fall down. I'm sure there's a puppy in it because they have puppies that are sick. Hiya, all new people that joined chat for the first time, and the people I didn't say hi to yet. Treasure. Okay, let's go. I hope my house doesn't fall down. That would be horrible. All right, this guy. Okay, so that guy had a chance to fix it easily. He didn't. This next guy had a chance to fix the easiest ticket in the world and didn't. Here we go.
Court will call Quentin Zimmerman, 2 cases, 22M 1344 and 22M 1665. This is what I call a county court dog at large, usually in Division C. I visit Adria Scheel.
Yes, Your Honor.
Okay, appearing as the prosecutor. Hello, Mr. Zimmerman. Did you understand your rights in the advisement?
Yes, I do.
Right. Are you now or have you ever been in the U.S. military?
No, sir.
It looks like in each of these cases, there were 2 failures to appear in October and November of last year, and then sort of at large yourself since that time. Bonds were set at $250 cash only. I'd be inclined to leave it at that, Ms. Scheel. I am not familiar enough with this type of case and these procedures to know whether the sheriff would ever bring anyone over to Division C on this, or do they appear by WebEx?
I do believe that the magistrate is now asking that people appear in person. We can try and make arrangements with the sheriff's office to get him. Our next dog docket that we have is on April 22nd at 10 o'clock in the morning.
Those are the dates that I have. I'm going to leave the bond there because of the 2 failures to appear. You got to work pretty hard in my division to get anything other than the PR bond on a petty offense. But when it keeps happening, I think at some point there's not much
Your
else
Honor,
that I can do. So
I was unaware that there was anything left for me to take care of. I was put in custody in Fort Collins for this case and transferred not too long ago, and I was told that it was taken care of. I was unaware that there was anything left for me to do, sir. Like, I'm gonna lose my job, my van, everything over a dog at large. Like, I'm begging the court, man, please PR me, let me get out there, get my vehicle, and so I can get back to work. I mean, this is really a very, very inconvenient time for me. I'm begging the court. It's a dog at large ticket. I'm not running away from this at all. You know there's just a misunderstanding, and I really don't want to lose my job.
weren't you picked up once before on this for a failure to appear? You got a new
I
court date.
was.
Why
I was
didn't you
picked
show
up
up the
on
second
this.
time?
I was.
I'm gonna leave it
I
where it
did.
is.
I was in custody, sir.
I'm going to leave it where it is. You can bring
Oh,
this up
please,
with
man. I'm gonna lose my job, my
Magistrate
van
Condil.
over this.
I understand, but I don't know what else to say. You failed to appear twice on 2 different tickets. I don't know the totality
I
of the
was unaware
circumstances.
Tickets were there, sir. I was
All right,
unaware.
that's it for today. Thank you.
That's. Ah, damn it. I'm kidding.
Corbin,
Dog
Cruder,
dog safer, dude.
when do you think you?
Court will call People versus Corbin Magruder, 24.
He's in jail because of a dog at large ticket. Now, I thought that was the end of this clip, but I still have time left. Maybe there's more in here that I forgot about. Let's just play it and see.
4M 1109. Hello, that's you?
Yes, sir.
Mr. Magruder, are you now or have you ever been in the U.S. military?
No, sir.
Did you understand your rights in the advisement?
Yes, sir.
All right. I reviewed the affidavit. I found probable cause for the arrest as an act of domestic violence requiring relinquishment. The charge is assault in the third degree as an act of domestic violence. When you're out of custody, do you own or possess or control any firearms?
No, sir.
I will mark the box. It looks like the deputies have had you mark that as well, so there won't be any other hearings on this. Is Ms. Geiger present, wishing to be heard?
I don't believe so, Your Honor.
Okay. I'll issue the protection order. Do not harass, molest, intimidate, retaliate against, or tamper with any victim or witness. Vacate the home of the victim. Stay away from the home of the victim and any other location the victim is likely to be found. Refrain from contacting or directly or indirectly communicating with the victim. Do not possess or control firearms, ammunition, or any sort of weapons, and relinquish firearms in accordance with Colorado law. Any exceptions being requested, Mr. Shirazi?
Yes, Your Honor. I would ask the court to, was the court inquiring about the bond hearing or
Protection order, and I usually do it in this order, and it's not a mistake in most of the courts, because if I issue an exception, my clerks get that done while we're arguing bond. If I do it the other way around, then they have two things to do at the same time.
There's not an exception.
An order itself. No exceptions? I'm sorry.
No exceptions.
Okay. So no exceptions right now. Bond argument, Ms. O'Hara.
Judge, I think it's somewhat academic in that the defendant was sentenced to COMCOR on April 12th in 23 CR 10 and 20 CR 982. Looks like he was sentenced to 5 years in community corrections. That being said, he does have a DVSI of 10, a CPAT of 2, and a total of 10. I'm asking for a $3,000 cash or surety.
Thank you, Mr. Shirazi.
Thank you. I actually don't think this is academic. Since Mr. Magruder was sentenced to community corrections, if the court sets a bond, unless he's able to post that bond, he won't be able to be transported over to community corrections to begin that sentence. For that reason, primarily, I am requesting that the court consider a PR bond here for 24M 1109. He would not be released to his own residence. He would be taken directly to community corrections, where he was sentenced just last Friday for 5 years community corrections. Apart from that, Mr. Magruder has ties here in Colorado. He's lived his whole life here. So there's not real flight risk concerns, along with the fact that he would be in a secure facility at community corrections. This would at least allow him to get programming started, treatment started, and he could come to court to handle this down the road while he's serving a community correction sentence if the court gave a PR bond.
Your response?
Judge, I don't think a community corrections facility is a necessarily completely secure facility where it's not going to be out in the community. Obviously, he'll have a bigger level of supervision, but he does have that sentence hanging over him. And Judge, quite frankly, I think with the facts of this case, let me go back to my notes, as well as the allegations and the defendant's criminal history, I think a cash or surety bond is most appropriate in this matter, and that's why I'm asking for that.
Well, the court is going to set bond the amount of a $5,000 PR bond. I don't think I'm required to do it, but I think I have the discretion to assist the defendant's two cases to mesh together. I agree, it doesn't provide 100% security, but certainly the defendant has other fish to fry if he doesn't comply with the structure and fairly strict parameters of.
Yeah, I didn't think that next one was a clip. I just cut it off way late. Hey, I'm a professional. I'm a professional. Hi, you guys in chat. I want to say hi, Elise, even though your name is Lizette. I call you Lisi in my head. Okay, so now, all right, this next one, one thing bothers me about it, and then, well, a couple things bother me about it, but let's see what you guys say.
Here's in person for the plaintiff, as well as a representative from Sun Four Seasons. What is your name for the record, ma'am?
Andrea Gagnon.
Okay, Miss Gagnon appears. And then I have Brittany Whitaker and Patrick Haas.
My last name is changed to Haas now.
Okay, would you like to amend the caption to reflect your current name?
It doesn't matter. I just wanted to make it known.
Okay, no, I appreciate it. So I'm guessing a recent marriage to Mr. Patrick Haas?
Yes.
All right, well, unless there's an objection from the plaintiff, we'll amend the name of defendant Brittany Whitaker to also be Brittany Haas, same last name as Patrick Haas. And then with that, folks, were you in court when I made my pre-eviction diversion announcement?
Yes.
Okay, Mr. Yaki, is there any interest in that program for this case?
No, Your Honor. This is actually a 30-day non-compliance with community standards and lease agreement. As filed with the court, there was a notice that was given on February 23rd, 2024 by Four Seasons to the Haas's relating to the ongoing issues with the condition of their home site and home, trash strewn along the way, failure to maintain it up to community standards. There's some photographs that we gave to the court and some violations that are a plethora of violations that go back for some period of time where Four Seasons has tried to work with these folks. Unfortunately, we just reached a situation where it's just it's a blemish, it's a health and sanitation issue, it looks horrible, it reaches the peace of other folks living in that community, and we just can't have these folks in the community any longer.
Have other community members complained about the defendants?
Not to my knowledge.
Okay, and Ms. Gagnon, how many times have you given notice to Mr. and Mrs. Haas about the violations?
You want to add them up, Andrea?
Is it more than 3?
It is.
Okay. Dating back, it looks like at least I see one in September of last year.
Yes.
Okay. I see September, I see December, I see February. All right, so Mr. and Mrs. Haas, have you received notices about the conditions of the premises?
Yes, we have, and we have also tried to communicate with her to understand better what exactly is expected of us as far as cleaning up. Photos are always very vague, her responses are always very vague, just a simple, it's just too much, clean it up, declutter. So we make attempts, we try to clean up the best that we can, and then we still turn around and get notice after notice. And our most recent one prior to receiving the notice to quit was dated for 2/22, but says to correct the violation by 3/22, leading us to believe we have a little bit of time there. Well, then we turn around the very next day on 2/23 and receive the notice to quit. So naturally we panic. We go down there and we say, are we being evicted? Do we have 30 days? What does this mean? And she tells us no, as long as things get cleaned up, it's not an eviction yet. If things do not get cleaned up, then yes, we will be evicting. So again, we go home, we try to clean things up the best that we can. It's mostly our children's toys, bikes, things like that are always being moved in different places because they play with them. And then again, we turn around and get the court papers. And so we're just very confused even through our attempts to communicate and understand what is expected of us, it's difficult when we look around and see other neighbors who have the same toys and things in their yards. And they're not getting notices, they're not being evicted, but here we're being picked on every time our bike moves.
All right, let me do this. Let me swear in all three parties other than Mr. Yakey. If all three of you would kindly raise your respective right hands. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Yes. I heard 3 yeses. Okay, you may all put your hands down. All right, let me start with Mrs. Haas. Mrs. Haas, you just gave me some background information. Is everything that you just told me true and correct, the underpaid
Yes.
penalties for perjury? Now let me go to Ms. Gagnon. Would you please state your full name for the record? I'm sorry.
Andrea Gagnon.
Okay, Ms. Gagnon, are you the person who issued the notices to the defendants about the violations?
Yes.
Okay, and were these based on standards that were written and published for the community?
Correct.
Okay, and when you gave a notice to quit in late February of this year, did you give 30 days for the situation to be remedied before filing suit?
Yes.
Okay. It looks to me that the suit was filed on April 1st of this year, so that would have been beyond 30 days after February 22nd. Is that how you see it?
Yes.
And after giving the notice, or perhaps 2 notices in late February, did you monitor the situation and wait and inspect over the course of those 30 days?
Yes, we did look at it and we did call them and tell them that it needed to be straightened up some more. And they came in and I talked to them, told them that all the clutter needs to be picked up, that it needs put away properly, and when it's not in use, it needs to be put away.
Okay, and I know the pictures are hard to see, and maybe it's my eyes or maybe it's the black and white concept. Could you describe for me in words some of the things that you were seeing which led up to the notice being given in late February and which then would have continued into March?
Toys everywhere, clutter everywhere, just stuff amongst their yard, just not put up properly. They have a lot of stuff up against their house, broken blinds. I do have them in color if you need to.
Okay, if you have them, I would like to, they're easier to look at, that they come in kind of grainy here. Thank you.
I think it's this
Yeah,
whole
just
one.
packet, yeah.
I just make sure I'm giving them the right one.
Thank you.
Very different color pictures.
Yeah.
This is their shed. Yeah. No, I just got these pictures. Oftentimes when I was good about setting the color online, but I think she copied it.
Oh,
So I owe me a little bit. But then I don't know, I think the transmission.
I'm going to hold on to this for a minute, but I will ultimately return it. It appears to be the same thing that was filed with the court,
Yep.
just in color.
Yeah.
All right, so I see most of the notices that were given talk about no outdoor storage, or a couple of other things noted, but that seems to be the main one. I'm not sure, folks, do you have a storage shed or some kind of?
We do, yes. And we also put a cabinet type thing out there for like our gardening supplies and things. Most of the time we try to keep the bulkier, you know, bikes and cars that our kids play with, like between the house and the shed, or we'll put it up on our porch so that it's not strewn out in the yard. And like I said, it's difficult to know what exactly they mean when we look around and the neighbor next to us has 3 lawnmowers parked in his yard, and the neighbor on the other side of us has all of their bikes behind their deck, and so do we. So it's like, how are we any different than our neighbors, you know? We do the best that we can to keep it cleaned up, but like I said, we have 3 kids who are constantly in and out, pulling the bikes back out, we're putting them back, and it's just difficult to keep up with on a daily basis. So sometimes, yeah, they are left close to the driveway or whatever, but they're typically picked up within 24 hours.
And how old are your 3 kids?
6, 4, and 1. And I'm also pregnant.
Okay, congratulations. Give me 1 second. I want to look at your lease.
By the way, your lease is month to month.
They are?
Yep.
All right, so the lease that was filed, it looks like it's an old one. That's a 12-month lease commencing December 1st of 2021. Ms. Gagnon, has there been another annual lease, or did it continue on a month-to-month basis?
I believe that they're up to date, that they've signed a new lease.
Okay, and do you know the terms? Is it, I'm only guessing, but would it be commencing December 1st of 23 and going until November 30th of 24? That would be a year lease.
Yeah, they annually, yeah, they
Okay.
renew.
And what, do you know the term of your lease, folks?
We attempted to re-sign another year lease, and she told us that we were on a month-to-month basis. So we pay a monthly fee for being on a month-to-month basis now.
So that's when they have.
All right, so, and that would make sense why the last annual written lease is the one from 3 years ago that would have continued on a month-to-month basis.
And I'd also like to add, we're purchasing the trailer. We're renting the land.
Understood.
So it's like, kind of like, we thought, okay, if we ever wanted to sell it or rent it out or something, month to month would be better. But then she told us, even if we were on a year lease, it wouldn't matter, as long as we brought our tenant through them and they did the background check, credit check, everything would be fine.
Mm-hmm.
So then we were like, well, let's sign another year lease. And she basically told us that we couldn't. So we stayed month to month.
Oh, I know.
Right. And that is a landlord's prerogative to say, no, we're not gonna renew it but on an annual basis, but we'll do it on a monthly basis.
Andrew, did you just remember something?
So once they are past a certain term of not signing the renewal, they aren't allowed to sign it until the next time that they are able to renew, which would be whatever the beginning of the last lease was.
Okay.
So I think they have like 3 months grace period to sign it, and if they don't sign it within that period.
Then they become month to month.
Okay, so they're currently month-to-month tenants.
Yes.
All right, so folks, let me share with you, under Indiana law, month-to-month tenancies are terminable or able to be ended by 30 days written notice, whether there's a violation or no violation. So, and that's the landlord's prerogative. They can terminate you for any reason whatsoever or no reason at all, as long as it's not a federally precluded reason based on race, sex, creed, etc. So at the end of the day, if they decide to give you notice and say, we're done leasing the lot, they can do that. Now that certainly creates problems when you are purchasing a mobile home unit that sits on the lot. And for that reason, Mr. Yakey knows this, typically I give a little bit longer than the 10 days that I do in standard apartment rent cases. But nonetheless, at the end of the day, there appear to be violations, there appear to be continued violations, and most importantly for me, there does not appear to be a written one-year lease that gives you the right to be there until the end of November, as I was guessing might be the case. So that being said, recognizing you have a unit, what I'm trying to do here is maybe get to a point where I can give more than 10 days, but still have an agreement to vacate, to move on, to give you time to either relocate the unit, sell the unit and get a different one, or rent somewhere else, etc. Instead of 10 days, and even instead of the end of the month, which would only be 14 days, I might propose to go 30 days. Let me start with the plaintiff. Mr. Yakey, is there any objection if I were to enter an order and use 30 days as an out date?
No, Your Honor, that's fine.
Okay, and folks, would you be able to move on relocating within 30 days from today?
We could do our best, yeah.
All right, let me do this. Let me find that plaintiff's entitled to immediate possession. We'll issue a writ of restitution, but instead of the standard 10 days, we'll give until May 16th at 11:59 p.m. That's the full days. It's 30 days from today and a little bit more. So May 16th, 11:59. And then folks, I'll set a money damage hearing for the same June 4th date I've been using for others. So you should plan to come back to court June 4th at 10 a.m. to talk about any money damages. Oh, it is. Okay, I apologize. In this one, we already have one. It's June 4th at 9 a.m. So you should come for 9 a.m., not 10 a.m.
Okay, and in the event that we can't move the trailer, what happens then, since we are paying a mortgage on it?
Understood. You're welcome to contact the plaintiff and see if there is any agreement. If there's not, you're welcome to write a letter to the court. I can't promise you that I'm going to do anything, as I'm already giving more than I typically do in time, but I would say make your best efforts and keep in touch with everyone, and we'll go from there.
Okay, thank you.
All right, folks, I wish you good luck.
Thanks.
Thank you.
On purpose,
All right.
I left a little bit of the next one in here.
Next, I have Floyd Bowling against Kyle Bowling. This is, oh, I'm sorry, I'd like to return the color.
Oh, thank you.
Floyd Bowling versus Kyle Bowling. This is 2404 EV 466. Right. I'm guessing I might have Floyd Bowling, is that correct?
Yes, I'm Floyd.
Floyd, okay. And also, what is your name?
I'm his daughter, Angie.
Okay, thank you, Andy. And what is your name, ma'am?
Vicky?
And Vicky, are you affiliated with Kyle Bowling by chance?
Yes.
All right, and what is your relationship to him?
Grandmother?
Okay, and how old is Kyle?
27.
Okay, is there a reason why he's not here himself?
That I don't know.
Okay, well, let me say this
He
for
is 27, right?
Yeah.
let me say for the record, under the small claims rules, I'm allowed to have an attorney appear for someone. I'm allowed to have a spouse appear for someone, but I'm not allowed to have a grandmother or a brother or a son or a mom or dad for that matter. So technically, I'll show that Floyd Bowling appears, Kyle Bowling does not appear. And now the question becomes, Mr. Floyd Bowling, this was an eviction hearing. Are you seeking to evict Kyle?
Yes, I am.
And what are the reasons for that?
He's violent, he's disruptive, he causes arguments in our family between his dad, me, his grandmother. He's attacked me years ago, but probably most recently, a couple weeks ago, knocked me off my feet.
Okay.
All I was trying to do was stop an argument between his father, him, and my younger son, Sam. So.
And so you are the owner of the property, correct?
Yes.
Okay, let me take some sworn testimony. Please raise your right hand for me. Please raise your right hand for me. No, sir, you're the plaintiff. You're gonna be doing the talking. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, yes I do.
All right, you may put your hand on. What is your full legal name?
My full name, Floyd W. Bowling.
Okay, and Mr. Bowling, you are the owner of the property in question, correct?
Me and my wife, yes.
Okay. Typically, we pull a check and determine if there's someone other than the named plaintiff who is listed on the property records as being the owner. And my staff did not indicate there was any discrepancy here. So typically, that would mean that it might be listed as only named in your name. Did you recently file a new deed by any chance with your wife's name on it?
Did I file a what?
A new deed showing who owns the property?
A deed? No.
We both own it.
Well, that's awkward. No, honey, you don't both own it, dear. You might want to look into that. You might want to get on that. Okay, so back to the first case. I understand the answer is going to be no, they're in a month-to-month lease, so it doesn't matter. But let's pretend. Let's just pretend for a second they're not in a month-to-month lease, and they're in a lease till November. All right? Now, she's saying all the other houses look the same. There's lawnmowers, and there's bikes, and there's things like that out. I wonder if she would have brought pictures of the rest of the units, the rest of the trailers there. Like if the judge would have, so it's written, the rules are written, you're not allowed to have outside storage. So, you know, I guess they can't keep their bikes outside or their lawnmowers outside or anything like that. But if everybody in the neighborhood, well, maybe not everybody, but a lot of people in the neighborhood have all this stuff outside and they don't have notices, these people can't just single them out legally, right? Or can they? Because the lease says you're not allowed to have outside storage. Also, I don't even know if they don't get rid of that mobile home. They have a mortgage on it. It's there on that land. If they can't sell it or move it, like what can the judge do? What can the judge? I guess the judge can, I guess, get it towed. Can you tow them? Can you just get a tow truck to tow them away? I don't know, but how? I don't know. That just a couple things about that bothered me. All right, we're gonna go to another guy who only had something really easy to do and didn't do it. But this guy ain't stupid. Don't worry.
You hear me?
Yes, Your Honor.
All right. I think I also have his probation officer on the line. Ms. Kelly, tell me what we're doing.
Judge, the offer in this case just changed. So I would just be asking for one last set over, for Mr. McGee to be able to consider it. And I did receive word from the facility that one last set over would be all right.
Any record, Mr. Shields?
Yes, Your Honor, we were trailing a Boulder case for some time, but I don't think that would be in the best interest to continue to do so. I've let Ms. Kelly here know that on the new offer, and that it's not accepted by the next court date, that I'd ask to have matters set for
Oh, sorry. I do want to know, Your Honor, that the Boulder case, they did just get the blood results in their last hearing, and their next hearing is set for the 25th.
Okay. Ms. Just, I see you on the line. Can you hear me?
I can. Can you hear me?
Yes, ma'am. Is there anything additional that you want me to know?
I guess just that, I mean, I had an appointment with Kevin today. He didn't appear, which is concerning considering his remote breath results. He continues this kind of compliant, kind of not compliant. But I would like to give him another appointment today, if I can.
Your Honor, I also wanted to note that Mr. McGee does have ulcerative colitis, which acts up kind of out of the blue at some point. That is why he's appearing over WebEx today. And it does keep him from traveling because he does not have a car. He does only live several miles from the courthouse. But it is extremely difficult for him to walk while he is having his bout of ulcerative colitis.
Well, it's interesting because he's also got a warrant out of the Boulder case. So I find that interesting that he isn't here today and didn't meet with probation. Mr. McGee, you're walking on thin ice, quite frankly, and certainly had you been here today, you would have been taken into custody. I think you knew that, and I think that's why you didn't show up to probation and you didn't show up here. So you need to report to probation today. You need to deal with that Boulder warrant, and you need to figure out how you're going to move forward because, quite frankly, you're continuing to test positive for alcohol. You're pending a third DUI. And these all raise serious concerns about community safety risk. And so you've got some decisions that you need to make, and chances are you're going to be taken into custody if you do show up. So I'll be interested to know if you actually do show up.
He won't show up. He's not going to show up. I mean, all he had to do was show up, and he would have been fine. I know she says, you know, oh, you had some failed tests, blah, blah, blah. They wouldn't keep him in jail for that. You know them. It's Colorado. Is that Colorado? Yeah, that's Colorado. So he would have been fine. He would have been good to go. And he only lives a couple blocks, like what did she say, a mile or 2 miles away from the courthouse? He could make it there. He's not that ill. He's just messing up, guys. People are just messing up. All right, I was going to go to Judge Fleischer and then end it. Instead, I'm going to do one more. Because this one's a little weird.
Call Newport Beach Police Department to have them get into the apartment. It's indisputable that at the time she left the child in the care of the father. I don't even know why this case was filed. I definitely don't know why we would keep her away from her child when she's the sole care provider.
Ms. Henderson?
Your Honor, what I have is the defendant and a couple of other people were at the defendant's apartment and drinking alcohol. The party went to work. The reporting party attempted to call the defendant multiple times, but the defendant did not respond. Upon returning from work, defendant and the reporting party walked out from the apartment. They had a verbal argument that occurred between them. The defendant then left with her friend, changed the door code on her phone, preventing the reporting party to get inside the apartment, and left their 3-year-old child inside the apartment. The reporting party attempted to call the defendant 50 times, 50, but she did not respond. The reporting party had to call the police and paramedics in order to gain access to the apartment to get his child, who was locked inside the apartment on the 2nd floor. The defendant admitted to leaving to go to Balboa Island with Uli and stated that she left the victim because, quote, he had a father.
I would just note that the police report doesn't indicate anything about my client or even the alleged father saying that she changed the door code at that time or at all. Door code, he didn't have it for whatever reason. It may have been changed, making it seem like it was changed in that moment. I think is adding facts that aren't in the police report.
Is CPS involved?
That
I don't know, Your Honor.
Okay. This is a difficult situation because we're at an arraignment stage. Obviously, there are defenses that can be presented at trial, and that's what Ms. Soares is bringing to light. What Ms. Henderson, who is not the filing deputy, but what Ms. Henderson is telling me about is what's in the police report version. The police report version is basically that a 3-year-old was left alone, locked inside an apartment where nobody else was able to gain access to that apartment. It seems undisputable that when the officers did get there and get into the apartment, the 3-year-old in fact was left alone. What's in dispute is who was supposed to be in the apartment with the 3-year-old. Apparently what Ms. Reynoso is claiming is that the 3-year-old is supposed to be with the father. The father is saying that he was locked out and unable to get into there to be with the 3-year-old. So there's definitely a dispute, it sounds like, regarding the facts, but that's what a trial is for. Ms. Henderson, do you have more information?
Yes, Your Honor, I'm just looking at the police report. On page 7 of the police report, the officer indicates on April 14th at approximately 7:30, Officer Wayne contacted the Orange County Child Protective Services. He spoke with the senior social worker, Kathy Bridges. He informed her of the circumstances surrounding the case. Bridges provided the officer with a CPS case number. That's the extent of my knowledge.
And I would just clarify one thing. I don't think that the baby's father ever says he wasn't left in charge of the child. I think that's the common understanding of what happened is they were in a disagreement about whether she should leave or not. She decided to leave anyway, and she left the child with the father. Whether he was locked out or not, whether she was aware of that or not, obviously is a trial issue. But it seems like both parties agreed at the time that he was, at that point, going to be in charge of the child.
Which the child is in an apartment that he doesn't have access to.
Right, but she's here, he's not. He also left the child in the apartment alone. They live there together. At this point, we don't know who changed the door combination, at least according to the police reports that I've read. So I think there's a lot of assumptions that are being made, and certainly that's the right of the district attorney in filing something, but with the facts that we have as they are, I find it very strange that we would be ordering her to not have any contact with her son.
Ms. Henderson?
On page 6 of the police report, the officer indicates, I spoke to the defendant again. I asked her if she was gone from the apartment for a couple hours. She said no. The officer asked why a mother would leave her baby by themselves. She said because he has a father. The officer asked why why the reporting party and her initially left the apartment. She said it was because they were arguing. Officer asked if at any point during the argument period that she changed the lock to the door because she was mad at the reporting party. She replied yes. I asked why she did not return to the apartment if she knowingly changed the door code, preventing the reporting party from gaining access to the apartment to check on the victim. She said she did not return because her other brother has a door code and he lives in Costa Mesa with her parents.
Okay. Once again, there's a lot of tribal issues, it sounds like, but in the end, what I have to do at arraignment stages, I have to kind of, I've heard all the facts, but I've got to go forward with what I'm hearing on the facts here. What is indisputable is there's a 3-year-old who was left in the house without somebody there. It was a locked door that people could not get access to. I am going to sign off on the protective order at this point in time, which is ordering that she have absolutely no communication with Julian, stay 100 yards away from him, his home, his job, his vehicle. Now, the other location that's listed on here, is this the location that both her and the dad lived together at? She is indicating yes to the court. The child is with Protective Services, it looks like, or at least they've gotten involved in some way. I'm not sure if Child Protective Services is going to be removing the 3-year-old from the home or what's going to happen. It looks like the two of them live together at 940 West 18th Street, C1 in Costa Mesa. Is that only his address?
That's his address.
Okay, well then you'll have no problem staying away from there. So I'm going to order that you stay away from his address. Now, we did mark box 14B, which means that any future court can change this court order. So if a future court sees it appropriate to go ahead and change this court order, they can do it at that point in time. But for the time being, ma'am, you're ordered to have absolutely no communication with Julian, and you must stay 100 yards away from Julian's home, any vehicle that person is riding in, and the location that is listed on this protective order. You cannot text, you cannot call, you cannot anything to the 3-year-old at this point in time. You're ordered to have absolutely no communication and stay away. But a future court can change this, and I will also set this for a protective order hearing on the next court date in that regard. Now, with regard to her release status, which is the next thing Ms. Soares wanted to address before she set dates on this, the only thing I see in her past is she has an arrest from January of 2023 in Las Vegas for domestic violence. I don't know that it's gone to a conviction. What is your request, Ms. Soares?
I'm asking the court to OR her.
All right. Ms. Henderson, if you can look and see if she has any other prior convictions.
Your Honor, I'm looking now, and what you noticed is what I have.
Okay. The court, of course, is concerned when I see an arrest, but I'm not going to be able to hold that against her in any way when I'm looking to whether or not to release her, because it is just an arrest. It is not a conviction. I do see that happened in January of 2023. I don't know what the resolution of it is. And then now we have this case. It looks like there was some decision making that was going on regarding alcohol as well that is not great. But I will go ahead and I'll release her on her own recognizance with that protective order in place. Ms. Henderson, is this going to be done over your objection or with your consent?
Over my objection, Your Honor, thank you.
All right. So, ma'am, I'm going to release you on your own recognizance, okay, which means you're going to get out of custody. But that does not mean that your case is over. I am going to order that you disclose release terms upon contact with law enforcement, and you have to obey that protective order. If you violate that protective order, you will be back in custody immediately. So that'll violate your release conditions as well as result in a new case being brought against you. You're ordered to maintain contact with their attorney, and you're ordered to appear at the next court appearance in person. Now, with her getting out, Ms. Soares, what would you like to do regarding dates?
I'm asking for the court to set it for this Friday the 19th for a pre-trial and the jury trial date of July 7th.
So, I mean, it sounds to me, hi Tammy, it sounds to me like she locked the kid in there and changed the code because she was mad. Sally's here. Oh, Sally, I hope you're okay. So it sounds to me like she did exactly what they said she did, but she's saying she didn't, even though she told the cops she did. She locked that house with her little kid in there and left him with the father who can't get into his own house. That, yeah, she's gonna. I know the lawyer said, either of them could be in there and only she is. Well, yeah, she's in there. All right, guys, it's time to go to Harris County. We haven't been there in so long. Here we go.
Open the car door, start fighting this guy. According to my client, he was the designated driver. They went into this place to go eat. The other guys were drinking. They had an argument with these people before going into the place. And when they come out, the argument ensues for whatever reason. My client says he tried to break it up, and then the fight ensues. So that's where we're at. Like I said, he didn't, he was just in the middle of everything, but and the police report kind of reads like that. But I mean,
I asked you to do one thing. What did I ask you to do? Stay out of trouble. You picked up an assault. Now we're revoking your bond on the DWI. You're going to jail. And I'm telling you now, you pick up a third case, I'm going to make your bond so high, you're going to flip. You understand? I'm ordering you now not to have any contact with any of these people whatsoever. No weapons, no driving, anything. You understand? Let me see. I mean, I hope that there was not a bail order or there was a affidavit that you signed promising us you wouldn't drive, because then I'm going to have a contempt hearing.
his license is good. He won the ALR hearing.
Judge, who's this on?
Bravo. All right. So he goes with you now, and then I'm going to set the bond at 5,001 on the DWI, and then that's it.
You know what? Hang on to this, because I think they checked this in with you, Joe. Because I don't know, I'm going to Washington for like a conference. I'll lose this. Right, is that right? He'll be with his property, right?
Yeah.
Okay, I'm gonna call you.
So, no contact, no weapons, or the other bond?
So I'm going to have him now he'll be monitored because, yeah, so don't even worry about it. It'll be with Jeremiah. So now I'm going to put a curfew on him. He can't go out in the middle of the night. No contact with the co-defendants. Treat him like a little child. Last.
It was all in jest.
I've got thick skin.
Judge, I'm assigned to represent Ashley Andrews here today. She has a motion to revoke probation.
Yeah.
And the motion to revoke probation primarily has to do with fees that she's behind on. I know.
No, she didn't do her DWI education class, the educational skill level.
Did do the victim impact panel.
That's the only thing she did.
And she does have the guardian interlock, but her car's not running, so.
She hasn't had the interlock for 4 months. So I think we probably just cut loose ends, just be done with it.
Or we can either extend her and give, so she can get the fees and everything caught up.
How much time does Sanders have? Please, Carl, I think just cut it loose and just be done with it, She may have, I'll just give her credit for the time she's done. What is it?
1 day.
1 day. We should be done. Does she really want to go through the thing again? I mean, can she really comply with it?
I've talked to her, Judge, and I think she can get it done. If we can either grant her a bond, so we can give her maybe a 2-month reset to get her everything taken care of.
2 months?
The most. I mean, it's $790 is what she owes. Or we can extend her. She was on 9 months probation. As opposed to a year or 18 months.
Let me see how well she's done while she was on bond.
She has reported to a probation officer. As a matter of fact, she reported in February and in March. Did not know that. And she was just told to come to court today. But she does report.
She has faith that she can drive this. That's all. I would say.
Judge, if we could extend her for 3 months.
She had nothing but problems while she was on bond as well. I mean, I don't know, Carl. I'm not. There has to be some kind of punishment, though. I'm not going to let her, if she wants it, she'll have to earn it, because there has to be some kind of punishment so she gets that we mean business. I mean, if you want to do a weekend, We can extend her.
Can we get some type of bond set for her and see if she
I have
can
a
get
bond set at 5,001 now
5,000?
and one.
Consider 2,500.
Oh,
Because it's primarily, we're talking about fees primarily. And I don't.
come up, Miss Anders.
That's what I,
Why do you want to continue?
I don't want to continue. I got a new job. It's the fees and everything with the DWI education class. I had to pay for that. And I just moved back to my mom's house, so I can't afford everything. I was making $14 an hour. I just got hired on at the Center for Children with Autism, which is a better paying job, so that I can pay.
You had nothing but problems while you were on bond as well. And now we're on probation. It's the same thing. It's a recurring theme here. So what is going to change?
I don't do it. I go to my probation visits. My drug test, I don't feel it. I do everything.
How do I know you don't have your device? You haven't had it for 4 months.
I don't have the device is in the car. The device doesn't work. I have messages where I talk to my probation officer and I let her know that. And she said, okay, I spoke to them. They emailed me. They came to my house and everything for that monitor. They came, they recalibrated. He even tried to fix the car. The key was stuck in the car. The car would not start. He tried to fix it and everything. I took pictures and everything and sent it to her as well. Like
She still has the guardian interlock. It's in her vehicle.
It's still, that don't work.
The mechanic came by and reviewed it, but they haven't
interlock.
removed it from the vehicle yet.
The interlock people came to my house and everything. Like I did everything. I'm trying.
I don't know. I mean, because we had to revoke your bond multiple times while you were on bond just for the DWI. You had bond violations while you were on the DWI. And now it's the same story. So I'm just not convinced that you're going to be able to complete this successfully.
My fee, $790 I can pay next week. I can pay that. I can do my DWI education, the education part. I can get that paid for. I can get that paid for within the next 2 days. I can get signed up. I can get the monitor, the handheld.
You want to have the portable device as opposed to, she's not driving, but the vehicle's not operating.
Does she even have do you even have a license?
I have a driver's license. I don't know if it's.
Yes.
Anyone can have a physical driver's license. Is it eligible with DPS?
I believe so, yes.
Please.
It was, I don't think it was suspended for the DWI itself because she was on probation.
Cut all her fees. If I ever see you again on a violation, I'm going to make a note now that you will be doing 120 days in jail flat. If I ever see you again, do you understand? I'm telling you, I'm going to give you 120 days. I will give you 0 days credit if I see you again. I'm going to cut your fees now. The only thing that you're going to be responsible for is the interlock and the education class. You have a week to get the interlock, the portable device with you. Okay, I don't want to see you fail this thing again. You have, how long, when does she term?
2 days on the 19th.
Okay, let's extend her for 3 months. Okay, you have a month to get the DWI education class done. What else did she have to do? The community service?
Yes, sir.
You have 2 months to get the community service done. Ms. Andrews, if I see you again, you will be doing 120 flat, day for day. Do you understand? Okay, take a seat. Thanks, Carl. What? How's jail?
How's what?
How's jail?
Can't stand it. Can't stand it. I can't believe I'm here again.
Therein lies the problem. You want to go to prison, do you? Really? You're begging for it, Mr. Bazan. This is now your 3rd motion to revoke your probation on a 2nd-degree felony robbery where the offers start at around 7 to 8 years. The question is, what's it going to take to get you to understand? You now stand charged here with DWI, driving while intoxicated. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir. Okay, Probable, please. Hold on.
Officers responding to a suspicious vehicle call at 200 Weisenberger in Harris County, Texas. A red SUV was stalled in a moving lane of traffic, and defendant was a driver asleep with an open can of beer on his lap. Odor of alcohol was detected. Defendant could not balance to perform SFSTs. Defendant admitted he had been drinking. According to the defendant, he had been drinking for 7 days straight. HFD EMS was called to check defendant out. He was taken to Memorial Hermann because he reported not being able to breathe. A blood warrant was obtained and executed, and defendant was cleared.
Tell me, does Mr. Buzz?
He literally just stood in front of the judge and said, I can't believe I'm here. What? What do you mean you can't believe you're there? What did you think was going to happen? Drinking that many days straight.
Does on have a license, Pavel, please?
Judge, I can confirm that for you. It is eligible.
Do you have a Texas driver license, Mr. Bazan?
Yes, sir.
Do you have valid liability insurance in your name? Then you are not allowed to drive, and I'm going to have you sign with me today an affidavit promising me you're not going to drive until you get it. I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. Do you understand?
And, I'm back on my medication since I've been here, and I had an appointment on the 16th to go see Inmates to get back on my medication to help me with the alcohol and to help me with my mental health. And they've been giving me my medication since I've been here. So I'm
Why
back.
have you not been taking it?
I stopped taking it because I felt like it was helping me. It was getting me fat. And
Getting you fat?
yeah, because it was making
Now what's going to happen? Now you're in custody, man.
So I already had an appointment before this happened. I had an appointment already on the 16th, and this happened. You know what I mean? So I was trying to seek help out there, but I'm back on my medication. And here they've been giving me my medication since I've been here.
You know, the problem, Mr. Bazan, is that I don't know why you don't get this, that, you know, the medication is supposed to do wonderful things for you when you take it. And when you, listen, I'm trying to talk to you and you got this mice running, figure out things to say and you don't hear it. When you start feeling good, you say, oh, you know what? I feel great. I'm not going to take this medication anymore. And then all the shisa hits the fan. It continues to happen over and over and over. When you take the medication, good things happen. And when you stop, what happens? You end up in jail. Perhaps you should stop taking the medication. Continue to take it and good things will continue to happen. Problem is, now you're stuck like Chuck. Who knows what's going to happen? You're now being held at no bond. Who knows when you're going to get out? Continue to take the medication. And I am now making that a condition of your bond. You don't take it, I'm going to keep you with me until you take it for an extended period of time. You understand? The only other thing I'm going to say is it's damn near elementary that you're not supposed to have alcohol in the car while you're driving. That in and of itself is a minimum of 5 days in jail, Mr. Bazan. Get your brother, man. So he goes with you and then so out of jail, gets a scram if he's released from custody. No drugs, no alcohol. They won't do the scram prior to release. Okay, then 1 day if he is released. Okay. Obviously, of course. Yeah. Mr. Bazan, keep taking the medication. All right, guys, good luck.
Who else feels personally called out about the mice running around in their head? Judge, that was mean. Leave me alone.
I need him to sign it. Yeah. Simpson, I need him to swear to this too, please. Do you need a translator?
No, sir. No, sir. Do I bring him up, Judge? Okay. Mr. Lister? Mr. Lister, go around. Go around.
Okay.
Yeah.
Sir.
Good morning, Mr. Lister. Sir, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're going to reduce it to a first, and they're offering you 30 days in jail, credit for the 1 day that you've done. I will accept this offer, Mr. Lister. The problem is now is that you have 2 on your record. What happens next time?
It's felony,
Right.
jail time.
No, prison time. Minimum of 2 years in prison, a maximum of 10 years in prison if you ever pick up another one. And it doesn't matter if you're drunk. It doesn't matter if you're slightly buzzed. The smell alone, in and of itself, will be enough for them to take you down and charge you with a felony. And if you think that this costs you money, wait till you get charged with a felony. Then it's big time money.
Yes, sir.
You understand?
Yes, sir.
I would never get in a car, even if you've had a sip of wine, half a beer, because it's going to cost you tons.
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you can never change this, undo this. You were stuck with this forever.
Yes.
How do you plead to the offense, sir?
Guilty.
I will find you guilty. I'm going to suspend your license for a year. I will sentence you to 30 days in jail. I'll give you credit for the 1 day that you've done. Now, you said you wanted to turn yourself in May 1st? 5th. Show up on time.
Yes, sir.
If you do not, they will not take you, and then I will have a contempt hearing. You understand? Okay, guys, good luck.
Thank you, sir.
Thank you, Mr. Hunter.
No, thank you, sir.
Yes, sir.
You know, I don't have to worry about not driving if I take a sip of alcohol. Because I've never taken a sip of alcohol.
Mr. Torres back yet again. You now stand charged again with an assault bodily injury. You're facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions in any of these. If you cannot afford a lawyer will be appointed to represent you, sir.
On March 22nd, 2024, at Spring High School in Harris County, Texas. Sorry. Complainant is a 17-year-old high school student. Officer is with the Spring ISD PD. Witness, defendant assault the complainant with a closed fist. Complainant also had a video of the incident where the defendant can be seen pushing the complainant and striking the complainant with a closed fist. Complainant felt pain and sustained a minor visible injury. Officer also obtained a statement from another student witness. Complainant reports that defendant continues to harass through social media.
Mr. Torres, what happened to your school? Did you get kicked in? Did you get kicked out?
No, sir.
I'm ordering you as a condition of your bond not to go within 1,000 feet of this individual. I don't care where you are. I don't care where he is. You go near him, I'm going to put you in jail. I don't know what it's going to take to get your attention. Perhaps we're going to have to put you on our plan where we see you all the time. I'm now ordering you as a condition of your bond not to consume alcohol or illegal drugs, and I'm going to send you right now for a drug test. I want to know what's in your system. Can you send them now, please?
Yeah.
I'm ordering you no weapons, and I'm giving you a curfew with a GPS monitor so I know where you are at all times. If you're out past curfew, I'm gonna light you up. You understand, Mr. Torres? One way or the other, we're gonna get through to you. If I need to put you up on my knee and spank you like a little child, I'm gonna do it. But I'm gonna do it with a ton of jail time. You understand? Take a seat for me. Let's have him sign a reset first, and then he goes in the box.
You said 7 to 7 or 9?
Miss Dixon Santana?
Yes, sir. Yeah, you know who it is.
Okay, so you're only charged 2 counts of assault, right? Is that it? Okay, what are we doing?
6 months deferred on 1 dismissed. Yeah.
Which one are we going on? How old are you, ma'am?
Sir,
How old are you?
I'm 27.
You're 27.
Yes, sir.
Miss Dixon Santana, you're charged with 2 counts of assault. You've worked out an agreement where they're offering you a 6-month deferred on 1, which is a type of probation that if you successfully complete, you do not end up with a conviction on your record. This is the next best thing to a dismissal, but it's not dismissed. If you complete it successfully, you don't end up with a conviction. Do you understand?
Yes, sir.
To complete this thing, you must do a 2-hour anger management class and 16 hours of community service. No drugs, no alcohol, and don't get in trouble.
Yes, sir.
I will make a deal for you. If you do well, I'll take you off in half the time. So if you get your stuff done quick, we'll take you off quick. You could be done with this thing in 3 months if you really kick butt. Can you get this thing done?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you're entering into a contract with us today. You complete it successfully, fantastic. If you don't, I will issue a warrant for your arrest. I'm going to put you in jail. We're only going to talk about if you violated, and if you did, you're looking at an entire year in jail.
Yes, sir.
You understand? What about contact with the complaining witnesses in the case?
Your Honor, the complainants, doesn't look like they knew each other that much.
I'm also going to put no weapons as well.
We got no objection to no weapons, Judge. There's no contact, Judge. It's fine.
Okay. I'm also ordering you not to have any contact with either of the complaining witnesses in both of the assault cases, ma'am.
Yes, sir.
So no weapons, no drugs, no alcohol, random UA, the 2-hour anger management class, and the 16 hours of community service. What do you do for a living, ma'am?
Sir?
What do you do for a living?
I work for Resource MFG. I'm just a floater part-time.
Okay. If you can reduce your fees too, please, and we'll give her credit. Yeah. All right, ma'am. Good luck.
Judge, have a seat on this side of the car, okay?
It was nice to her.
I've been trying to print this bond violation for you, or I was trying to text it to you. It wasn't going through for some reason. You have it? Okay. Okay, talk to me. Okay, great.
Ready? Ready?
I'm ready when you are.
Sure.
You tell me.
Coffee?
Has he signed his stuff yet or not? Yeah.
All the paperwork, yes, Judge.
Got it. Good morning, Mr. Coffey. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. It's okay. You've worked out an agreement where they're offering you 3 days in jail. They're giving you credit for the 2 days that you've done. Understand, Mr. Coffey, this DWI is going to go on your record. It's going to be there for the rest of your life. If you're ever pulled over and you smell like alcohol or dope, what do you think is going to happen? Right. What we're doing today, it's not going to happen again. You're now facing a minimum of 30 days in jail. You understand? I would never get in a car, even if you've had half of a beer, because you're going to go down regardless. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to something, you're stuck with this for the rest of your life. You can never change this, undo this, challenge this. Do you understand? You still want to do this? How do you plead to the offense, sir? Sorry?
Guilty.
I will find you guilty. I will follow the agreement. I'm going to suspend your license for 90 days, sir. Don't drive until you get a license, and good luck. Thanks. We'll roll your court costs so you won't owe anything as well. Okay.
Gajardo, Fortunato, first name Gajardo, last name, doing a plea.
Ready?
Yes.
Okay, come on up, sir. All right, Mr. Guajardo, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you an 18-month deferred. This is a type of probation that if you successfully complete, you do not end up with a conviction on your record, but you cannot tell people it was dismissed. It was not dismissed. You merely, if you completed successfully, you completed it and did not end up with a conviction on your record. For you to successfully complete this, you must do a 2-hour anger management class. You must also do a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. No drugs, no alcohol, random urinalysis, no weapons, and no threatening, abusive, or harassing contact with Jeffrey Berg. You understand what's expected of you.
Yes, sir.
You must also stay out of trouble. Don't pick up any new cases. If you do, I will issue a warrant for your arrest. I will put you in jail. I'm going to bring you out. The only thing we're going to talk about is if you violated, and if you did, how long of a jail sentence you'll be doing. And I can put you in jail for an entire year. You understand?
Yes, sir.
You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So this is a done deal today. It's done forever. You can never come back and try to change this or undo this. Do you understand?
Yes, sir.
How do you plead to the offense, sir? I'm not going to find you guilty. I will withhold that for 18 months. Any particular reason why it's 18 months? Did you want him actually?
Yeah, TRAS and just keep him monitored for.
Will you have an objection if I early terminate, if he does well?
No, Judge, I wouldn't object to that, Your Honor.
It'd be a minimum of at least half the time though.
I know,
So,
but the TRAS is needed more than a year, so on paper it needs to be 18.
no, right, but if he does well, and that also depends on what the TRAS may say, who knows what it'll say, right? All right, if you do well, I will take you off in half the time. That means you're nice to everybody, no law violations, and you get everything done on time. Do you understand?
Yes, sir.
So that whatever the TRAS says you may do, if you fulfill all those and you're still within 9 months, I will take you off after 9 months. Do you understand? How did he say guilty?
Yes, sir. Yes, sir.
All right. Mr. Guajardo, we wish you the best of luck. Please see the clerk. Mr. Bueno,
Yes, sir.
how are you? How's jail?
Yeah, job been all right.
Do you know why you're here?
Yeah, for warrants.
Tell me again.
Warrants.
Come closer. Come to the bar. I can't hear you.
Warrants.
Correct. For what though?
No, just
The assault.
assault. Yeah.
You know what happened with the assault as to why you got arrested?
I was in a mental health hospital.
And then what happened?
Judge.
No, he's getting it. You're doing great, Mr. Bueno. You're doing fantastic.
Judge, this may go into.
Well, my point is that
I got hungry, and I asked the lady, I asked the guy for some food.
Judge, this is going into.
okay, Mr. Bueno, your lawyer here, Mr. Laredo, wants to get you into the Harris Center to get you help. My fear is that if we do that, another assault will occur. And I do not want that to happen. The reason you are here is because no self-control. You must exercise self-control. Do you understand? That's why you are in jail. Because when you get angry, you start going like this. And that's not what we do. Do you understand? How do I know if we take you to the Harris Center that it's not going to happen again?
I wasn't on my medicine at the time. I guess taking my medicine will help me to stay in self-control.
Are you taking it now? You're not taking your medication now?
Because I don't know which way to how to get my medicine.
Can we get him into medical or something so we can get him to the medicine that he needs?
Judge, my understanding is that they're, based on what I have access to, he's on something. They're prescribing something, Risperdal, I think.
Let me see.
From what I'm able to check on. What I saw. So he's on something, to my understanding.
I'm supposed to be on 5 medicines. 5 different medicines.
Judge, and this is one of those cases where I don't want to say too much, you know, but
we're here as
schizophrenia pops up so much on his history, Judge. For years, schizophrenia's been popping up, and so it's. I mean, the only reason I say that, I'm trying to get him some help, Judge. I mean,
Mr. Bueno, I want to get you into the Harris Center, but I want the people at the Harris Center protected. I don't want you to do anything like what happened at the other place. Do you understand? I will give you one chance, but if you fail me again, you will be stuck with me in jail for a long time. I will only release him to the Harris Center. And we need to know that when you speak to the people at the Harris Center, that he knows that they know about the tendencies so that they are protected as well.
so if I could just give you an update on why I'm proposing this, Judge. I did this in court maybe 3 weeks ago. The way this happened was, it was kind of the same situation where he needed help. I get in contact with somebody in the MAC. They tell me supposedly there's different programs or stuff. I explain to them what's needed. They make it happen with the Harris Center. We release him directly to the Harris Center, and then he gets his help. And then
I'm okay with that.
okay. And
but like I said, only if he gets released to them and they pick him up and they take him directly there.
right, that's what we were able to do last time, and that'd be their expectation this time as well.
Okay, I'm okay with that.
Okay. So I'm gonna roll it to what's today, Wednesday?
So
Friday?
perhaps reach out to Brad Morris so that we can get into like a mental health PTI or perhaps something like that, to that caliber, not necessarily a PTI or however they want to craft it. I don't care, but that they release him directly to the Harris Center.
Okay. I think Bell's kind of on board depending on what they say, but I'll keep working to that.
Judge, I think we should hold off on the PR bond until we have something set in stone.
I'm not giving them a PR bond today, of course.
I thought that was,
No.
I thought that was the direction where we're going.
No, nope. Not until I know where we signed the document and we have a releasing document to the actual Harris Center.
Yeah.
That's only until that.
My only concerns were, once I can file the order, but basically the Harris Center will just say, we don't have a basis. to hold
We're
it.
not ready yet.
Yeah, so.
Not ready. It's too premature.
And that's where
That's the route.
Yeah, that's where I'm getting in contact with Max, shirting everything up, so I have answers for you guys, and with the idea that he's gonna be taken care of over there, and I'll come back with you guys, but everybody's on board, it seems like, so.
Yes.
Okay.
Mr. Bueno, self Control.
Yes, sir. Self-control. I'm gonna try to learn to do that. Self-control.
That's why everybody's in jail, because they have no self-control.
Start doing that self-control.
Good. Good things will happen then.
Yes, sir.
Okay.
Thank you, sir.
All right, Judge, thank you for the opportunity. All right, Sam, I'll talk to you in a minute.
Mm, mm, mm.
Misdemeanor, no control over the felony. It's just the misdemeanors.
Ms. Williams, let's go through this. In June of 22, you had an interference that dismissed. In September of 2022, you had an injury to a child dismissed. In September of 23, an aggravated assault against a family member dismissed. Pursuant to that, you pled to a robbery and they put you on a probation for a robbery case. Since that time, you've now picked up in January of this year, a failure to stop being information. We gave you a bond, you got out. And now you've picked up another 2 cases. You picked up an evading arrest and a failure to identify oneself to a peace officer. Let's go through those. Do you mind going through probable cause on the 2 newest cases, please?
Yes, Your Honor. So on these cases, on April 13, 2024, officers were dispatched to an assault in Harris County, Texas. Officers arrived and observed a large crowd of people in the parking lot. Officer observed the defendant to be walking away from the scene. Officer told the defendant to stay at the location. Officer then spoke to an individual who stated 2 girls jumped her, and she has video of it. Complainant pointed out the defendant and stated she is one of the girls who jumped her. Defendant began to walk away again. Officer told the defendant to stop, and the defendant began running away from the officer. Officer chased the defendant. Defendant ran 100 feet before being caught. Defendant then gave the name of her sister. At JBC, officer read the defendant's prints that came back to the defendant. The warrant for arrest for the FSGI.
So she had the warrant out.
She had a warrant, I believe, for the.
Let me look at the names just to be sure which warrant we're talking about. It's going to be warrant out from Judge Nelson's court in the 42nd.
Yes. So she picked up the FSGI. They subsequently filed the motion to adjudicate.
Got it.
That
Okay.
was the warrant that was issued. That was.
So here's what we're gonna do. I am now revoking your bond on the failure to stopping of information. And they gave you 2 PR bonds on your 2 newest cases. I don't think so. I'm now revoking those PR bonds as well, and I'm gonna raise those up as well. And I'm gonna tell you, if you do get out again, I'm gonna order you under home confinement. Because when you get out, nothing good happens. You understand, Ms. Williams? The only thing we want are streets to be safe. And does that happen? Okay, so
I'm not saying you're guilty of it, okay? And we're just saying we right to a jury trial. We have to. It's just a matter of, the judge wants to make sure that you're safe and that everyone is safe if you get out, okay?
No.
All right.
The problem, Ms. Williams, is that you're on bond or on probation for a very serious robbery case where people go to prison for 20 years. The only thing we ask you to do is behave yourself. And when you put yourself in a situation where it's inevitable that bad things are going to happen.
Yeah, and Judge, I would like to say that Judge, dating in the failure ID, again, we're not conceding that they happen. We're just, but they are moments of being scared, Judge. And just, she's not out there.
I don't know. It sounds to me like she's not charged with another assault.
And again, Judge, it's just,
I mean,
she's not there stealing or anything else. It's some intentional thing. It is in the moment, it's obviously she's scared and she maybe makes a decision that she shouldn't make, but we'll look at the evidence, Judge, and approach.
Yeah. Okay.
Thank you, Judge.
Yeah, for sure. So for now, I'm going to set all the bonds at 5,003.
Yes, Judge.
And then we'll go from there, man.
reapproach it, we'll get some more information, Judge.
Sure.
As well as when we get some information on the felony.
They're not
Thank you,
gonna
Judge.
file any new cases, are they? The assault or anything?
That's unknown right now, but Your Honor, I think for now, the charges are just gonna stay at this.
Yeah, okay, all right, thanks, guys.
¿Qué tal? Solo mire, el juez le contesta en español.
Be happy.
nada más. ¿Cuál es su nombre, señor?
Antonio Vergara.
Ok, solo mira para allá. Antonio Vergara.
Is it River?
27, be like boy.
Got it.
Vergara.
Vergara.
Ah, era ese Vergara.
Are we doing a plea, Marjorie?
Yes, Your Honor.
What time are we looking at?
21 days with me.
Okay.
Mr. Belgada, you're charged with burglary of a vehicle. You are facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 21 days in jail with credit for the 22 days that you've done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this. Do you understand? From now on, if you pick up any future cases, you will be facing a minimum of 90 days in jail. You must also understand that if you continue to pick up these burglary of a motor vehicle cases, they can use these to enhance you to a felony. And then you will be looking at serious time in prison. Not only that, you live in Texas. You mess with the wrong person, they're gonna shoot you dead, like it happened 2 weeks ago. Do you understand?
Yes.
How do you plead to the offense, sir?
Ofensa. Solo míralo, a él le dije, no me mira a mí, escuche muy bien. Guilty.
Find you guilty. I will follow the agreement. Good luck to you, sir.
Dígalo oficial.
Okay. Señor, entonces.
That's it.
Thank you, Your Honor.
Okay, thanks, Marjorie.
Judge, that's it.
We're done.
So he didn't say that's a wrap, but he did say we're done. Thank you, Judge. Thank you so much for that 1 hour. That was lovely. Very, very, very enjoyable. Chat, you are awesome. Don't worry, chat replay is on. It just takes YouTube a day or more to put the chat up. I don't know why. I can't change it. I can't make it go any faster. So there's this Georgia case. It's a divorce, right? And I wanted it because the accents were really, really thick, right? But there was like no volume at all. I recorded it anyway. I recorded what they did today. They're still going tomorrow. I boosted it 100% 6 times to get this so that we could sort of kind of hear it. I don't know if I'm going to be able to play it or not, but wish me luck today, guys, because I'm going to be fighting with sound all day long. Don't worry, there'll still be good stuff if I can't get this. But Raven, love you too. Cloud, love you too. Yes. Yes. Oh, man. Guys, Carolyn has the best Australian voice. But she does a hillbilly that is outstanding. Is out of this world. Oh, you're right. Colette, you're right. YouTube is great. Everybody get on YouTube. Oh, gosh. All right, guys. Behave today. What is today? Today's Thursday for me. Friday for Carolyn. So, we almost made it. We almost made it to the end of the week. I will see you guys tomorrow, I hope. If I get enough stuff, I will see you tomorrow. I will. I mean, I'll at least play Fleischer. He's always good for an hour. Thanks for coming out. I really, really, really appreciate it. And the chat is great, guys. Just Read the chat tomorrow. You'll love it. It's so funny. All right. Be good.